For my part, I have not the judgment to conceive that such treason is agreeable to the fundamental grounds either of reason or of law. How can that make a thing treasonable which is not so in itself? Not of law, since neither statute, common law, nor practice hath from the beginning of the government ever mentioned such a thing. It is hard, my lords, to be questioned upon a law which cannot be shown. My lords, do we not live under laws? And must we be punished by laws before they are made? Far better were it to live by no laws at all, than to put this necessity of divination upon a man, and to accuse him of a breach of law before it is a law at all.
Hey everybody, I hope you're well. It's another day, another video, and today is ex post facto. So the case that we're going to be looking at comes from 1798, and it's called Calder v. Bull. And in this particular case, the judge shoved a lot into a relatively few number of pages. And there are 4 kind of big takeaways and a 5th bonus prize related to this case. So first, it's that ex post facto for constitutional purposes applies to criminal cases. And the judge provided 4 separate instances where that's going to be true. 2, the judge found that the United States Supreme Court doesn't have the jurisdiction to nullify a state law that's found to violate the state's constitution. 3, you can't compel somebody. You can't force a man to do what the law doesn't require him to do. And you can't stop him from doing things that are legal. 4, there wasn't a fact. There wasn't a thing done to Bull or his wife in this case. In effect, there wasn't anything to do with them at all in relation to the law that was passed in Connecticut, which we're going to get to. And then as a bonus feature, this judge also went forward with the idea that a property right is a perfect right. And if it's not perfect, you don't have it. So a little bit of background to make it a little bit easier. So an ex post facto law is quite literally a law done retroactively. In this particular instance, it's a law that was passed later that affected a will's probate. But in, say, a criminal case, an example would be prohibition in the United States in the 20s. If they had tried to use prohibition to put someone on trial for drinking a beer in 1910 when it was legal, that would be an ex post facto application of the law. And in the United States, the federal Constitution prevents ex post facto laws in 2 instances, in Article 1, Section 9, and Article 1, Section 10, which prevents the federal Congress and the states, respectively, from passing bills of attainder or ex post facto laws. And as I said, this case came from 1798, so fewer than 10 years from when the Constitution had been ratified. So all of this was still being developed at this time. So with that little bit of background out of the way, let's go ahead and talk about the facts of this particular case. On March 21st of 1793, a will for a man named Normand Morrison was disapproved, and the court refused to record that will in Connecticut. Now, Normand was the grandson of someone named Caleb Bull, wonderful name, and his wife. Because the court had disapproved the will, the contents of it then moved to a man named Calder and his wife, and they were set to then claim the property, the land that was held in that will. Bull and his wife, being quite reasonably perturbed by the turn of events, appealed the decision of the probate court. Unfortunately for them, they waited too long. The jurisdiction in Connecticut had an 18-month statute of limitations, which means they had to have filed their appeal with the court within those 18 months, and they didn't. As a result, they were precluded from doing so. Undeterred, the Bulls actually went to the Connecticut legislature, and they petitioned those individuals to pass a new law to allow for appeals beyond the 18 months for will probate issues. And a little more than 2 years later, the Connecticut legislature had agreed and passed a new law that allowed for this sort of appeal to occur. and appeal Bull did. And in appealing, he won. And the will was actually approved by the court in July of 1795. And of course, now Calder, unhappy with the situation, he appealed the decision of the new court, saying in effect that applying this new law to a will that was denied a couple of years back is actually an ex post facto application of the law, which is unconstitutional under our brand new, shiny, freshly signed Constitution. And in taking it to the Supreme Court of the United States, Calder's attorney argued a series of different strands of an argument that kind of wind together. So he argued the ex post facto issue. The attorney also argued that any law of the federal government or of the state government that's contrary to the U.S. Constitution is void, and the Supreme Court actually has the authority as a result to declare it void. The Supreme Court took a look at those arguments and started out their discussion with a brief evaluation of legislative power and the boundaries of that power. And as a general proposition, they made the point that a legislature can do just that. It can legislate and has the full power to do so, absent some limitation by the federal Constitution. And went a little bit further even to say that it makes sense, and I tend to agree with him, that the bounds of the legislature's abilities and powers are the extremes of what men would want of them to do. So it wouldn't make a lot of sense for an individual to give the legislature power to abuse him in some fashion. So why would you assume the legislature has the power to do so? The judge then went straight into his ex post facto evaluation, and he quite rightly noted that there was probably a reason that ex post facto was something banned in the federal Constitution, both against the federal government and against the states explicitly, and that reason was history. The British government had a rather nasty habit of getting rid of people using ex post facto laws or bills of attainder, largely under charges of treason. And one of those individuals you actually heard at the beginning of the video. His name was Thomas Wentworth. He was the first Earl of Strafford, and he was brought before the House of Lords on a bill of attainder, which is kind of like a judicial charge, except that it's an act of legislation that declares a person guilty of a crime and punishes them without a trial. And because there's no trial, you have none of those same judicial protections. It's a really sketchy deal. And quite often, the justification that the House gave for conducting these legislative trials was that the individual being accused of whatever the crime was, most often treason, was so dangerous that they had to be killed, they had to be gotten rid of for the protection of the sovereign himself. And this was the backdrop of the United States when we formed the Constitution and included things like a prohibition on the bills of attainder and ex post facto use. It was within this concept of extrajudicial punishment by the government of the citizenry. And so then he took the next step to try and figure out when this prohibition should apply, when it should be considered an ex post facto law and prevented. And he came up with 4 separate instances. One, when you pass a law and then try and punish someone for that behavior when they did it, it was legal. 2, when a law is passed that makes a crime worse and then you try to punish them in the worse way than when they actually committed it. 3, when you try to apply a new law that makes the punishment greater than it would have been at the time that the crime was committed. And 4, when you try to use rules that were changed against a crime before the change happened. And this is largely related to, say, rules of evidence and other court procedures. And in looking at these 4 particular types of instances, the judge made a very clear note that all of them ended up relating to criminal actions. As a result, the ex post facto denial in the Constitution related to criminal, not civil crimes. The judge turned then to argument number 2, which was basically that the Connecticut legislature had no right to pass the law that it did to begin with, allowing for the appeal because it was contrary to the Constitution of Connecticut. And because it was contrary, it was void, and the Supreme Court has the ability to say so. The judge disagreed, and he said that the Supreme Court has no jurisdiction to determine whether any law at the state level is in violation of the state constitution. That's a state issue, not a them issue. Take it to the state court. Moving then on to the general third holding of this case, the judge took a look again at that bound in nature of the legislature that we talked about earlier. And he went through and named a series of examples where an act of a legislature would be contrary to the social compact, the agreement between the citizens and the government, and that when the courts or the government itself violated that compact and overstepped, it couldn't be considered to be a legitimate or appropriate exercise of government power. Examples of this issue provided by the judge included the ex post facto law itself, a law that destroys private contracts between citizens, or when a law makes a man a judge in his own cause. Or another example was when the law takes property from one person and then gives it to another against the will of the person that originally owned it. The legislatures can do a lot, right? They can permit, deny, prohibit, but they can't change innocence into guilt, and they can't punish innocence as a crime. As a result, you get the idea that in a free society, in a free Republican government like we have, the government can't compel someone to do something they don't want to do if they aren't obligated under law to do it. And they can't stop you from doing something that's legal just because they dislike it. If they want you to stop, they have to pass a law. And then the court turned its eye on Bull, his wife, and the state of Connecticut. And we get to the fourth holding here. And that is that in this particular case, the court found there is no fact done by Bull or his wife that's in any manner affected by the law or the resolution of Connecticut. It doesn't have anything to do with Bull and his wife. What it has to do with is the law passed by the state of Connecticut and the probate court. This one can get just a wee bit tricky. The idea is that the law passed said that an individual could work against the probate court. They could appeal the probate court's order even more than 18 months after the order was issued. That law says absolutely nothing about Bull, and it doesn't address any of their rights or obligations or anything else. The law was specifically directed at the probate court. And because of that fact, there is no law, no fact, no thing that could be considered an ex post facto application when applied for Calder's purposes. So there, Calder was just SOL. And with that, the judge was left with just the bonus round, and that's property right. And in looking at this particular case, the judge found that property rights in and of themselves are perfect. He said that if anyone has a right to property, such right is perfect and an exclusive right. And the thing is that you can't have such a right before you've acquired a better right of property than anybody else. So in effect, you have to beat out everybody else before you have the property right. And so if all you have is a right to recovery, you don't have a property right at all. And so in this particular instance, Calder never beat out Bull, because if the will had been valid, Bull and his wife took the property, and Calder and his wife had no claim to it. All they had was the claim of recovery. And as a result, the law in question didn't even have any effect on a right that was held by Calder, and the decree against the will didn't vest or transfer any property right to them. And so, all being said, the Supreme Court upheld the approval of the will, and Bull and his wife walked away winning in this case. So that was Calder v. Bull and the ex post facto application of the Constitution. I hope you enjoyed this particular case. It was an interesting one that I hadn't read in law school, so it was fun for me too. Do me a favor, reach down in the comment section below and let me know what you think of the court's reasoning, in particular the ex post facto clause itself and its application to the criminal cases rather than civil when it comes to the constitutional prohibition. Be a really interesting discussion, I think. Anybody have anything to say on bills of attainder? That could be a fun conversation too. But until we get together again, I hope everyone is well.